Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to Our Curious Amalgam, the podcast from the Antitrust Law section of the American Bar Association. My name is Matthew Hall and my co-host today is Alysha Pannu. Hello, Alysha.
Hello.
Today's episode is How Should Intent Apply in Competition Law? A discussion with Maya-Salomé Garnier. We'll be discussing with Maya her 2025 book, Intent in Competition Law, published by Concurrences, which, as the title suggests, covers intent and its application in competition law. We have a link for purchasing the book in the episode details. Maya is a law lecturer at Aix-Marseille University in France, after law studies at Assas University in Paris and Aix-Marseille. She obtained her PhD in December 2023. Intent in Competition Law is the published version of her PhD thesis, originally written in French. It has won several prizes, including the 2024 Law PhD Award from Concurrences. Hello, Maya, and welcome to the show.
Hi, Matthew. Thank you very much for having me today. I'm very pleased to be here and to share my thoughts about a subject that has long been at the center of my research interests.
Excellent. Well, we're really looking forward to discussing it. Fascinating subject. But just as background and a reminder for our listeners, the underlying competition laws relevant to our discussion today are Articles 101 and 102 of the Treaty on the Functioning of the European Union, or TFEU. As listeners will probably know, Article 101 is the basic ban on anti-competitive agreements that are void unless justified on efficiency grounds, while Article 102 is the ban in the EU on abuse of dominance, again, unless justified. There are effectively identical rules at national level in the EU. EU competition law has evolved a lot over time. At a very high level, enforcement can be said to have started out as form-based. Then came the modernization that began in the 2000s with a shift to an effects-based approach that, in principle, focuses on real economic impact and consumer welfare. Arguably, we're now in a phase of further modernization where competition rules are influenced by, or at least need to take into account, societal objectives such as environmental sustainability, resilience, and industrial policy. So, Maya, Intent in Competition Law is a really amazing piece of work that covers a huge amount. What was the background to it, and why did you decide to take the subject on in the first place?
Well, I was doing a master's in business law, and during the competition law class, the professor who will later become my PhD supervisor, David Bosco, was talking about abuse of a dominant position, and he said the classical sentence, "It's an objective infringement, intent doesn't matter." That caught my attention, and I started thinking, well, that doesn't make sense. How can someone abuse their dominant position without meaning to? That really sparked my curiosity and made me want to dig a little bit deeper. So I decided to write my master's dissertation on the topic, but at the end of it, I was encouraged to continue and turn it into a PhD. And writing a thesis hadn't been my initial plan at all, but the idea of spending a few years surrounded by books, thinking and writing really appealed to me. And that's how this book came to be 4 years later.
That's great. I guess perhaps we can start with first principles, and maybe could you give us a bit of, set out briefly for us what you mean or what intent means in the context as you discuss it in the book?
Yes, of course. Well, what is really important to understand at the beginning of this conversation is that there is a huge confusion surrounding the notion of intent. From the very beginning of European competition law, the fate of intent was almost sealed. Most scholars rejected it in the name of the objective nature of the discipline. But in my view, that rejection stemmed from confusion between two distinct notions, intent and motives. And I believe this confusion was at least partly imported from the United States. Indeed, the American debate on intent sowed the seeds of a misunderstanding that has endured in Europe ever since. Think of Richard Posner's famous statement, "Any doctrine that relies on proof of intent is going to be applied erratically at best." What Posner meant was that competition law should not concern itself with the aggressive language of business executive. The fact that a company representative expresses a wish to defeat or destroy competitors does not, in his view, reveal an anti-competitive intent. It merely reflects the natural rivalry inherent in the market process. In the Olympia decision, for example, the expression used was quite colorful. These turkeys had to be flushed. But here lies the misunderstanding. Posner, among others, conflated motives with an intent. And let me explain the difference. The reason why someone acts, their personal motives, is not the same as the purpose objectively pursued by their conduct. Understanding this distinction is crucial if we are to grasp what intent really means. Let me illustrate this with an example outside competition law. Imagine pointing a gun at another person's chest and pulling the trigger. That behavior clearly shows an intention to kill. And notice, this is not as subjective as it sounds. Intent is not about what the person claims to have thought. It is inferred from conduct and from the surrounding circumstances. We reconstruct what happened and we infer what the person meant to do through their act. Motives, on the other hand, are something else entirely. They explain why the person acted. Jealousy, revenge, fear, profit in the case of competition law. Motives may serve as mitigating or aggravating factors, but they do not define the act itself. In short, motives describe the cause of the action, whereas intent describes its goal, the result that the person aimed to bring about. To put it differently, motives precede the act, intent looks forward to its purpose. In both European competition law and to some extent in US antitrust law, the two have often been blurred together, and as a result, intent has been dismissed, largely because it was misunderstood. And when we ask whether a firm intended to harm competition, that does not mean asking whether it wanted to eliminate its rivals. Of course it did. Every firm seeks to outperform competitors. That is the essence of competition itself. The real question is whether the firm's conduct, in light of the surrounding circumstances, reveals a will to restrict competition as a process. That is, whether the behavior is capable of producing such restrictive effects. If the conduct is inherently capable of restricting competition, then we may presume that the firm intended to do so. That is the proper meaning of intent in competition law, not a subjective inquiry into what was inside the CEO's mind, but an objective inference from the nature and consequences of the conduct itself.
Thanks, Maya. I've never heard it put so clearly, but that certainly makes the distinction between intent and motive very clear. So I'd like to hear what you think about the current relevance of intent in Articles 101 and Articles 102.
Yes, of course. Let me start with Article 101. And rather than giving you an example right away, I'd like to walk you through a line of reasoning. Because my research shows that intent is always present in competition law analysis, not occasionally, not exceptionally, but implicitly in every single cases. We often hear, both in the EU and US competition law, that proving anti-competitive agreement is all about showing its effects. In EU law, this idea is tied to the distinction between by-object and by-effect restrictions. The object approach is often compared to per se rule in US antitrust. Once an anti-competitive object is found, the harmful effects are presumed. In other words, even when we focus on the object, the ultimate concern remains the effects. This is the classical doctrine. But this reasoning raises two logical problems. First, ever since the earliest rulings of the Court of Justice, a mere attempt to restrict competition can be sanctioned, even if the conduct was never implemented or never achieved its goal. The notion of agreement under Article 101 was modeled on the concept of conspiracy. What is punished is the anti-competitive plan itself. Yet, in the case of an attempt, there can be no effects since the conduct was never carried out. This means that effects are not the constitutive element of the infringement. Both under EU and US law, an agreement can be sanctioned even if it has not produced any actual effects. Logically, this implies that intent plays a greater role than effects, and then the paradigm is reversed. There is a second problem. Some might argue that without harm to the market or to consumers, there can be no competition infringement. But that's not necessarily true. To understand this, let's look at the problem from the opposite perspective. A price increase, the exclusion of a competitor, a reduction in output are not in themselves unlawful. They can perfectly result from a legitimate merit-based competition. This means that an effect taken alone tells us nothing about whether the behavior was anti-competitive or not. And yet, we often define a restriction of competition through its effects, saying that a practice restricts competition if it produces an anti-competitive effect. That's a circular definition. To see this more clearly, let's once again take an example outside competition law, fraud. The result of fraud is the transfer of something, money or property, for instance. But that result by itself isn't illegal. People can transfer property all the time under perfectly lawful contracts. It's only when the transfer is obtained through fraudulent means that it becomes unlawful. In other words, what makes fraud illegal is not the result, but the means used to achieve it. The same logic applies in competition law. In a cartel that was never implemented, just like in an attempted fraud, what is punished is not the means and the intent that it reveals, not the outcomes. The result is not unlawful in itself. It becomes unlawful because of the way it was pursued. And the same reasoning applies to abuse of a dominant position, Article 102. In both EU law and under the Sherman Act, an attempted abuse or an attempt to monopolize can be sanctioned. And that tells us something important. Actual effects do not always need to be demonstrated for the infringement to exist. We often think that intent only plays a limited role in abuse cases, for instance, as a kind of plus factor in predatory pricing. But that's a misunderstanding. In those cases, what's usually called intent is actually motives, the business or strategic reasons behind a company's behavior. And motives, just like effects, can serve as a supporting evidence that an abuse occurred. Yet neither of them, neither motives nor effects, necessary or sufficient on their own to establish the infringement. What truly matters is the intention to use means that fall outside competition on the merits. In other words, what distinguishes lawful from unlawful conduct is not the outcome, but the fact the undertaking relied on unfair, artificial, or deceptive methods. And this is exactly what happened in the Google Shopping case. The issue was not simply that rival comparison services were ranked lower in search results. After all, search engines necessarily rank content. The real problem was that Google manipulated its own algorithm to systematically favor its own comparison service while presenting the results as neutral and objective. In doing so, Google misled both users and the market about fairness of its ranking mechanism. So the abuse was not the demotion of rivals per se, but the deceptive manipulation of the ranking system. That is the mean by which Google secured that advantage. Once again, it is the same logic. The infringement lies not in the outcome itself, but in the method used to achieve it.
That's a really interesting and clear analysis there, Maya. And I think you set this out very clearly in your overall conclusion in your book, where you say that competition infringements being formal in nature, they are consummated independently of any result. They are attempts elevated to autonomous offenses. So I think, as I understand it, that's your summary, really, of what you were just setting out there by reference to Google Shopping and the other types of cases. So quite a lot of your book sets out some issues with the current use of Article 101 and 102 of the treaty and the relevant national provisions. It'd be interesting to hear your take on what the problems are. I mean, you've already referred to inappropriate use of intent and motive and the distinction between them, but it'd be interesting to hear some more analysis of what you see as the issues with how the law is currently implemented in this area.
Yes, well, there are several problems. And since the early 2000s, economic analysis has taken on an increasingly dominant role in EU competition law, inspired by the Chicago School and the so-called more economic approach. Economic reasoning now occupies far more space than it used to. And let me be clear, I am not opposed to economic analysis. What I oppose is its omnipresence and the idea that it should dictate legal outcomes, making the result of case depend entirely on economic modeling. And in the European Commission's practice, we often see that the Commission itself calls superfluous or redundant economic assessments, analyses that go far beyond what is necessary to establish the infringement. And this trend has created serious implementation problems. Many Commission decisions are now overturned not because the facts were wrong, but because of disputes over technical details, the choice of an economic test, the structure of a counterfactual model, or the parameters used in a price-cost analysis. We are witnessing, in a way, the judicialization of econometrics, which slows down and weakens enforcement. And it's a paradox because the very focus on efficiency has made enforcement less efficient. This over-reliance on economic tests also undermines private enforcement, especially standalone actions, those not based on prior authority decision. In the European Union, our collective action mechanisms are already weak, and it's unrealistic to expect an individual victim to bear the enormous burden of proof or to finance complex and costly economic expertise on their own. And the system has simply become too heavy because we have become obsessed with effects since the modernization of EU competition law. And yet the Court of Justice itself has never embraced this enthusiasm. It has never overturned its earlier case law and has never made the proof of effects a mandatory step in competition analysis. In focusing so heavily on effects, we've lost what made EU competition law distinctive: clarity, predictability, and speed of enforcement. A renewed focus on intent, on the means used rather than the end results, could bring the law back to a more coherent and efficient path. This is my thesis.
I noticed on this issue of the use of economics, a comment in your book that the use of economic analysis implies significant political bias disguised by a false scientific neutrality. Obviously, I agree economics is not a science. What are some of the problematic ideological and political biases that you think are embedded in this reliance on economics and econometrics?
I think that the political bias that we can find underlying economic analysis was for the Chicago School an anti-state political ambition. That means we were really afraid about over-enforcement. So we prefer not to enforce competition law rather than condemning conducts that are not harmful to competition. Yeah. So I think that this was important in the EU system, this fear of over-enforcement in the name of efficiency. And I think that it is a huge political bias because scientific theory has to be neutral. I mean, when you are trying to predict the weather, you are not trying to influence the decision making of a country. So it is a huge difference. Or where you treat someone's disease, you are not trying to influence the decision making. So the difference between classical science and economic science is that economic science has an influence on the decision making, on political decision making in the case of competition law. And I think that we should not treat economic analysis in the field of competition law as a neutral element, as something that is not political at all. I think we should integrate it in the debate, but as a political element and not a scientific one.
So you've kind of perhaps alluded to this already, but what would be the benefits of moving to an intent approach under Articles 101 and 102? Would we find that clarity, predictability, and speed of enforcement that we're looking for?
Well, I think that there would be several benefits. Returning to a more legal approach does not, of course, mean abandoning economic analysis entirely. This is not about returning to some imaginary golden age, but about restoring the proper place of legal reasoning and refusing to allow economic reasoning to dictate outcome as the sole frame of analysis. A more legal approach would allow to rely on simple, intelligible presumptions, which enhance legal certainty and the effectiveness of competition law enforcement. Presumptions, far from being formalistic, serve as instruments of rationalization. They simplify without distorting, making the law understandable for both businesses and for national courts. And this refocusing is especially necessary because it invites us to ask us again the fundamental questions, too often sidelined in technical debates. What constitutes anti-competitive conduct? What means can legitimately be judged contrary to fair competition in a liberal economic order? These questions are legal before they are economic. They call for answers grounded in a substantive conception of competition as a normative value, not merely as a measurable market situation. And this perspective is central to the thesis I defend. Competition law infringement can be understood as a form of fraud, not in contractual relations between parties, but in relation to the market itself. In contract law, misrepresentation vitiates a party's consent by altering the process of forming the agreement. In competition law, anti-competitive conduct operates analogously. It distorts the competition process, prevents economic actors from making informed choices, and disrupts the market in a way that interferes with how exchanges should occur. The transaction does not happen as it ought to, not because a contract is vitiated, but because the competitive framework itself has been compromised. In other words, competition law sanctions a systemic form of fraud, a deception that operates not inter partes, but nes. Market power amplifies this deception, turning a localized distortion into a structural imbalance. This conception, which echoes aspects of the ordo-liberal tradition, emphasizes not the measurement of effects, but the very nature of the behavior, its disloyalty, manipulation, or deception toward the market. And what struck me in my research is that this framework allows us to coherently encompass all practices currently sanctioned under Articles 101 and 102. Cartels, exclusionary practices, exploitative abuses can all be seen as a variation of the same deceptive logic. Each distorts the competition process by manipulating the conditions under which economic actors exercise their freedom. In this sense, the theory of intent I propose is not revolutionary. It does not aim to innovate, but rather to reveal the internal coherence of competition law as it is already applied. By describing more accurately what judges are doing, it allows us to better understand positive law and make it more predictable. And the merit of this approach, I believe, is that it restores competition law to its properly legal dimension. The focus is no longer on hypothetical effects, but on the loyalty and fairness of the conduct in relation to the principles that underpin free and undistorted competition.
So, Maya, as one paragraph to cover both 101 and 102, which reads something like, the following are prohibited insofar as they are liable to affect trade between member states, i.e. EU member states, and provided that they do not pursue a legitimate ground, which I think would mean objective justification or maybe efficiencies as well, conduct adopted by an undertaking aimed at restricting, individually or collectively, the free formation of the conditions of exchange with the aim, I guess that's your intent coming in there, of obtaining an undue advantage. So a result that is not, if you like, fair in the marketplace. So do you want to comment on that paragraph before we move on? Because I thought it was it seems to be kind of a key point in your document, your book.
Yes, it's illusionary to think that it can have an effect. I think there will not be any reform, any new TFEU, including this proposal. But in fact, when I studied the history of competition law and I read Article 419 of the Penal Code of 1810, I was really impressed by the simplicity of the wording of this article And I think that it was clearly sufficient. And it was puzzling to me to realize that maybe it could still work today with something, because what you read was inspired by this very ancient article. So yes, that's my comment.
Well, I think you're right about amending the TFEU.
Okay.
Needless to say, but it's pretty extraordinary that jurists back then produced something which, yeah, indeed, you still think would be pretty useful and workable today. So in terms of practical implications, I mean, as we say, you're not going to change the treaty for sure, but what do you see as practical implications of this analysis on intent and the various concepts you've discussed here for day-to-day advisors, if there are any?
Yes, of course, there are practical implications. The book highlights several points that might be of real interest for practitioners and advisors. First, it shows that defenses based solely on the absence of anti-competitive effects simply don't work, because effects are not a constitutive element of the infringement. That's why arguments such as efficiency defenses, individual exemptions requested under Article 101, paragraph 3, or objective justifications under Article 102, based on effects, all tend to fail, always. They just don't fit within the legal reasoning of competition authorities or the courts. But there are other possible avenues for defenses that are far less discussed, those based on legitimate ground. In other words, the firm may argue that its primary intent was not to restrict competition, but to pursue a legitimate objective, provided that the conduct was proportionate and necessary to achieve that purpose. This line of reasoning opens up a much more nuanced approach to defending certain types of behavior. Finally, since the book seeks to offer a substantive definition of competition law infringement, arguing that it is in essence a form of intentional wrongdoing combined with market power, it also provides conceptual tools that lawyers can use to challenge certain legal characterizations made by competition authorities.
Well, I think I will definitely keep the book on my shelf and take some of those comments into account. Before we move to our final section, Maya, just very briefly, if you could mention if you've had reactions to the book, whether from other academics, and what you're going to do next in this area.
Oh, well, my thesis has received several awards and has allowed me to begin an academic career in France. The French version of my thesis was published this summer, and the English version just has been released, so it is still a bit early to talk about reactions. I do occasionally receive messages and questions, and I can see that my work is attracting interest, and a lot of interest actually, which I found very encouraging. And in the years to come, we will see if it inspires further research against broader sport, or has a concrete impact on competition. And at this point, there is nothing more I can do.
So we like to finish off our episodes with a couple of personal questions, Maya. So firstly, could you please tell us something interesting or unusual about yourself that we would not know from only working with you or from your professional life?
Oh, well, I do enjoy what I do. I do enjoy really law, but it was not my first passion. I think I've always been more drawn to philosophy and literature, although I love them too much to want to make a career out of them. And one of the criteria for choosing my apartment was having enough space to fit all the bookshelves I needed. And another thing, I grew up on boat in Marseille, and my father was a diving instructor. Nobody studied law or studied at all in my family before me, so I feel very attached to the sea. and I would never want to be far from it.
Was that free diving or is that scuba diving?
Oh, that was scuba diving, but I prefer free diving now, and I do it with a monofin.
Okay, and how deep can you go with your free diving?
Or I went up to 40 meters.
Okay, well that sounds pretty deep. We'd like to have our final episode, which is the Curious Hat.
And now it's time for the Curious Hat.
Well, as an author, I thought it would be interesting to ask you about when you're not working on your own books, what types of books are you reading? In particular, what is there a book that you're reading right now, and what do you think of it?
Well, I always have about a dozen books on my bedside table. Currently, there are essays. So I'm going to try to translate the French titles. The Waning of the Middle Ages by Nga. So, very interesting about the Middle Ages. The Clean and the Unclean, the Hygiene and the Body since the Middle Ages, from a French essayist, historian. Then I'm reading The Sense of Life from Adler, which was contemporaneous to Freud. And then I have novels also, of course, such as The Devil's Pool, de Georges Sand. I just read the last couple of days Bibliomania from Flaubert, and the last novels I finished were Perfume. I really recommend it. It's a really interesting little novel, Perfume by Hoskin, a German novelist. Master Flea, the E.T.A. Hoffmann, and a book that I really liked. I don't know if there is an English translation, the Alexandre Dumas fils. That's it. Maybe I have other, but...
Well, that's a great list. I think we could all add them to our reading list. Maya, thank you very much. It's been a fascinating discussion. We look forward to reading your further work. Alysha, thank you very much. And thank you to all our listeners. Until next time.
Thank you.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.